Hi, Mr. Garg. Welcome back to my channel. Hope you're doing
Uh,
well.
Yeah, thank you so much, Parul, for calling me again. So I'm doing well, very well.
Perfect. So, for the audience, Mr. Garg is the founder of File My Return, which is a very famous site back in India. And for any kind of NRI taxation, everything, please watch the channel. And also, I'm going to be linking their website in the description box. For any kind of consultation and services, please feel free. But also, Mr. Garg is a regular guest at my channel, and we have been talking a lot on NRI financial topics, right from taxation, capital gain tax, buying of property, selling of property. And today I am with another topic which is very relevant for NRIs, which is around the gifting. Because Mr. Garg, as you must be knowing, that a lot of NRIs they may be receiving some gifts, let's say from a family or extended relatives, etc. And at the same time, they might also be giving away gifts to their family or friends. So I think my questions today would be around that. How does the taxation work in case if an NRI is receiving a gift or if they are, let's say, giving gifts? So let's just start with the basics. Maybe if you can walk us through the history of gift taxation in India. How does it work?
Of course. So gift taxation in India has undergone significant changes over the years. Initially, before 1998, gifts were taxed under the Gift Tax Act, and the responsibility for paying the tax fell on the giver. So whoever was making the donation, or not donation, but the gift to the NRI, they needed to make a gift tax. This meant that if someone gave a gift, they had to declare it, and then they had to pay the required tax. Okay, but after 1998, the gift tax was abolished, and for a brief period, there was no tax on gifts at all. But then in 2004, a significant shift has occurred. So, as per the new provision which was introduced in Income Tax Act, and which it reintroduced the gift taxation. Okay, but this time the focus shifted from the giver to the receiver. Under the new rules, now gifts could be taxed in the hands of the recipient, but only in specific situations, not in general wise way, but only in specific situations, which we'll talk in a bit. This change or this new provisions, they marked a complete overhaul in how gifts were taxed in India and made it essential for individuals, especially NRIs, to understand the nuances of these rules. So they need to understand these rules very, very clearly.
Right, that's quite interesting. So, what kind of assets can NRIs, which is non-resident of India, what kind of assets they can receive as gifts or maybe through inheritance in India?
Okay, so Parul, an NRI has several asset categories they can receive as gifts, either by way of gift or by way of inheritance in India. Okay, so let me break it down into four or five major ones. The first one being money or liquid funds. This could involve direct monetary transfers or deposits into their accounts, right? Second would be the immovable properties. This refers to the land, building, or other real estate projects. But there are certain categories which are permitted, and there are certain categories which are off the books. So for that, they will require some certain permissions. So the third category would be jewelry, painting, art pieces, and other valuables. These are considered valuable goods and are regulated very, very closely. Okay. And now for the fourth category, it would be shares in Indian companies. So any equity or other types of shares in the companies registered in India can be gifted by any relative. Okay. Then the fifth category would be shareholding in a limited liability partnership. So there are entity structures in India, one of them being a limited liability partnership. It's also registered under the Ministry of Corporate Affairs. So any shareholding in that ownership stakes can also be gifted to an individual NRI. Okay. So, but when NRIs receive these assets, these transactions are governed by the FEMA guidelines and the Indian Income Tax Act. So these regulations ensure both legal and the financial aspects of such gifts. And as such, these guidelines are very, very well defined. So there's no ambiguity in those guidelines. So each type of assets come with their own set of rules and laws, which they will have to abide by. And we'll be explaining them one by one as we go along this podcast.
Let's maybe begin with the immovable property. When I say
Okay.
immovable property, means the real estate. So what are the rules for gifting property or real estate or
Mhm.
immovable properties to
Sure.
NRIs?
Sure. So, gifting immovable properties to NRIs is permissible under FEMA and income tax rules, but there are some specific conditions, as I mentioned earlier. So, those conditions have to be adhered to. So, let's begin with the condition number one. So, what are the permitted properties which are allowable to be gifted to NRIs? Okay. So, when we were doing our previous podcast, in which we had said that NRIs looking to buy property in India, they can only buy residential or commercial property. So, same rules apply out here. So, only residential or commercial properties can be gifted to NRIs. So, agricultural land, plantation properties, or farmhouses are strictly prohibited from being gifted to NRIs. These type of properties can only be gifted to Indian residents who are citizens of India. So, barring these three, the other residential or commercial properties can be gifted. So that was a condition number one. Then their condition number two is around tax exemptions. So the gift of immovable property is exempt from taxes in certain cases. Those cases would be first, if it is received from a relative, that immovable property is gifted or inherited from a relative. Second, if it is received on the occasion of recipient's marriage. So, in case anybody is getting married, either you are gifting your daughter or your niece or someone, so that way, or your son-in-law or whatever way, it's being gifted on that occasion of marriage, that property is being gifted or inherited. Then, if it is received under a will or by inheritance. Then the fourth one would be if it is received in contemplation of the donor's death. So your father has died and you are the legal heir, and in that condition, that property is being transferred in your name. So that way, the gift of immovable property would be exempt from tax. So, and then the fifth one would be if it is received from a local authority as defined under Section 10, subsection 20 of the Income Tax Act. So, local authority could be MCD or MCG, whichever way, the municipality or any other local authority which they are giving the property to the NRI. Okay. And the sixth one, the final one, would be if it is received from a trust or an institution registered under Section 12A or 12AA of the Income Tax Act. Now, if the property is gifted without any consideration to someone who is not a relative, the recipient will be taxed on the gift. That means if a person to whom the property is being gifted, the immovable property is being gifted, he's not a relative, okay, and it is being gifted without any consideration, then the recipient who is receiving that property, he will have to pay tax on that gift. So the taxable value is determined based on the stamp duty valuation of the property, right? So this was the first two conditions. Now for the third condition, the valuation rules. So if the property, as I explained, if it's gifted without consideration and its stamp duty value exceeds 50,000 rupees, then the value is that value, which whatever that actual stamp duty value is considered for tax purposes. If it is gifted with consideration, the recipient is paying some consideration, then the actual transaction value is taken as the value for the valuation purposes of income tax. Okay, so then moving on to the fourth condition, the sale proceeds and repatriation. So NRIs, whoever who receive this kind of gifted properties, they can very well sell the property, and oppose the sale of this property. They can remit the proceeds outside India in case they have inherited in the past or they have received that gift in the past, but now they wish to sell that property. So in that case, they can very well do that, but and they can remit those proceeds, but that can be done only up to a limit of $1 million. That is, and that too through the NRO account every financial year. That is a basic condition which everybody knows. Most of the viewers would be
Yeah.
knowing. But
Yeah.
and this limit also applies for the property sale receipts.
Yeah.
Yeah,
Fine. So we've discussed the immovable property, but then let's say, what about jewelry or other valuables? Because sometimes people have gold or other jewelry. Like, first of all, let's define what jewelry is. Is it like gold
sure.
or is it applied to jewelry? And then what do we have any special considerations for jewelry or something different to, let's say, real estate, or how does that work? Because in India we
Yes.
have a system of jewelry, right? Like gold, for example,
Yeah,
and people accumulate a lot of jewelry.
women generally have a smile on the face when the word jewelry comes in, definitely. All right. So, so the
That's
rules
not the
of
only
jewel.
reason for my smile, by the way, Mr. Garg.
Okay. So, yes, the rules for jewelry and valuables have their own intricacies. So, under Income Tax Act, the Indian Income Tax Act, jewelry includes first the ornaments made from gold, silver, platinum, or other precious metals, regardless of whether they contain precious or semi-precious stones. So that is not a consideration whether they have or they don't have it, but gold, silver, platinum, and other precious metals are counted as one. Then any precious or semi-precious stones, whether set in articles, furniture, or even apparels, because many what do you ladies say? Gold plated sarees and all. So those kind of things, those are also counted in the jewelry. Okay. So if there's precious or semi-precious stones, the jadau stones, somebody says, so those are if embedded in the apparel, so they would be counted under the jewelry category. So if these items are gifted without consideration and their fair market value exceeds 50,000, the recipient is liable to pay tax on the fair market value. However, if the gift is received from a relative or it is received under other exempt categories such as inheritance, no tax is levied. So it is very clear. So in case this is being received from a relative, there would not be any tax. But in case it's not being received from a relative, you're receiving from someone else, and the value is more than 50,000, then the recipient will have to pay tax. So NRIs have to ensure proper valuation of these items, especially when transferring them internationally, as FEMA guidelines and custom regulations also come into play. So that piece of jewelry or whichever way it is held by the recipient, it is crossing international borders. So those customs and FEMA guidelines come into play. So need to be very, very careful and vigilant in terms of having it properly valued. So those proper valuation certificates should be in place.
Yeah, yeah, makes sense. And I think I remember you mentioned about securities earlier, right? So
Yeah.
when I say, let's first define what are securities, just
Hmm.
for the benefit of all the viewers, so they at
Sure.
least understand what securities mean. And then let's also talk about what are specific rules for gifting securities, either to NRIs, or let's say if NRIs want to gift to a family member in India.
Hmm. So, Parul, when I mentioned securities, by securities, I meant equity shares, debentures, or preference shares in Indian companies. Now, those equity shares may be listed or unlisted, irrespective. It's a shareholding in the company. So, whether it's in the form of equity or preference shares, listed or unlisted, debentures, convertible, non-convertible, nature does not matter. But primarily three categories you need to be mindful of: that equity shares, debentures, and preference shares. These are the securities we are talking about of the Indian companies. So this gifting is allowed to NRIs, but they come with several restrictions. So restriction number one, prior RBI approval is required. The resident donor, so the resident Indian donor must obtain prior approval from the Reserve Bank of India for such transactions. It cannot be they just transfer the shares to any NRI. It won't happen. They will have to acquire that prior approval from NRI, from RBI, sorry. Then the eligibility of the NRI. The NRI recipient must be eligible to hold such securities under FEMA regulations. It should not be that FEMA has banned a certain category of individual NRI or group of NRIs to hold Indian equity shares. They have been so they would not be able to receive by way of gift also. Then there's a limit on the value of the gifts. So the total value of securities being gifted by the donor in any financial year must not exceed equivalent of USD $50,000. Okay. And then also the second limit would be around the paid up value of the capital of the Indian company. So the gift must not exceed 5% of the paid up capital of the Indian company. So even if it's below $50,000, the paid up capital of the Indian company, the gift cannot exceed the 5% threshold limit. Okay. So then the fourth restriction around gifting securities would be around the sectoral cap compliance. So the gifting must not breach the sectoral cap on foreign investments in Indian company. So what happens is that in insurance sector, let's say, a foreign company cannot hold more than 74% share holding in any Indian insurance company. So if we were to talk about an NRI having a foreign company, they pick up some more shares through some Indian Indian shareholder, and their shareholding, total shareholding in Indian company exceeds 74%, then that would not be allowed. Okay.
Mm.
So then the next would be around the who is defined as a relative out there in that case. So the donor and recipient must be relatives as it has been defined under the Indian Companies Act 2013. So the relative definition would be governed by the Companies Act 2013 out here, not by the Indian Income Tax Act. So tax-wise, if the securities are gifted between relatives, there's no tax implications. But if gifted to a non-relative, then again the fair market value is used to calculate the taxable amount in the recipient's hand. So these rules are designed to ensure that such transactions comply with both Indian financial regulations and taxation laws.
Mm. Fair enough. And I think we were talking about family and relatives, right? So
Yeah.
there must be a definition of a relative, let's say.
Mhm.
What are like how does somebody qualify as a relative under these
Sure.
provisions that you were mentioning?
So we'll need to evaluate those relative definition under the two scenarios. One is from the Indian Income Tax Act. Second will be from the FEMA point of view. FEMA is more or less similar with the Indian Companies Act. Okay. So if I were to talk about Indian Income Tax Act, under Indian Income Tax Act, the relative definitions include spouse, brother and sisters of the individual or spouse, means your brother-in-law or sister-in-law. Then the parents and parents of the spouse, the lineal ascendants and descendants of the individual or spouse. That means your grandparents or your great-great grandparents or your granddaughter or grandsons, that way lineal ascendants or descendants of that individual or of the spouse. So they are the relatives who are covered under the Indian Income Tax Act. And when I said FEMA defines relatives similarly, but aligns with the Companies Act 2013, which includes spouse, father, son, son's wife, daughter, daughter's husband, brother, and sister of the individual. So these are the relatives which will be covered. So when I was talking about the securities, so I mentioned that securities, that definition of relatives is governed by the Companies Act. Companies Act and FEMA Act, these two acts align with each other very well. For other gifting purposes, I was talking about always I have been talking about from income tax standpoint. Whoever are covered under the Indian income tax standpoint, only those relatives would be covered.
Right. And what about, let's say, monetary gifts? Are there any limitations? Let's say up to a certain threshold only you can gift. Like how does that work?
So yes, there are restrictions around that. So under the LRI scheme, the liberalized remittance scheme, NRIs can receive monetary gifts from resident Indians within an annual limit of USD 2.5 lakh dollars. Okay, so gifts from non-relatives, if they are exceeding 50,000 rupees, then they are taxable in the NRI hands. But from relatives, they can surely receive gifts up to 2.5 lakh dollars. So Indian parents can also gift money to their NRI children without any tax implication if it qualifies under the relative definition.
Right. And let's say, what about the NRIs who are gifting assets to others? When I say others, as in somebody who's not a family or a relative, is it possible, or there is no provision of that?
There are provisions around that. So NRIs can gift their assets, but the rules differ based on the asset type and the recipient. Okay, as we were talking about the other asset types we have just spoken about, so they are also applicable. The rules and regulations and the provisions apply to NRIs also. So, for example, NRIs cannot gift agricultural land, plantation properties, or farmhouses to other NRIs or PIOs. They can gift these three properties only to a resident Indian citizens. Next, if NRIs want to gift to his or her parents in India from their accounts, they can only do it from their NRE accounts. What that would help, gift received by the parents would not be taxable in their hands. So that way, they would be saved from the tax implications. If NRIs want to gift shares to their relatives, they can gift shares to an Indian resident again. They cannot gift it to any other NRI or PIO. And the gift would not be tax. This would help the gift not being taxable in the hands of the donor. Then the recipients of the shares would be taxed in India if the fair market value of those shares exceed rupees 50,000. Okay. So, and or if the recipient does not qualify to be a relative as per the income, as per the act. So, in these scenarios, the NRIs can very well go ahead and gift the particular asset type, and also to whom is giving the gift, the recipient. Based on that, the tax rules would apply to them.
Yeah, yeah. Cool. And I think this has been very comprehensive. And let's just maybe wrap this segment with a slightly more broader perspective, because I read somewhere that there are some key differences in gift taxation, specifically between India and the US. So
Mhm.
just wanted to understand a little bit, like, what are those differences in gift taxation between India and the US?
Okay. So, Parul, the key difference lies in who bears the tax burden. In India, the recipient of the gift is generally taxed, except in exempt cases like gifts from relatives and those received under a will. But in US, it's the donor who pays the gift tax. It's the reverse. So this applies only if the donor, again, this rule will apply only if the donor is a US taxpayer, such as a US resident, or he's a green card holder, or he's a citizen of US. For NRIs, no gift tax applies if the donor isn't a US taxpayer. He's just gone there for some assignment, but he's not become a resident, or he does not have a green card, or he's not a citizen, then no gift tax will apply on the NRI. Okay. This means that when a gift is made by a resident Indian to anyone living in USA, then no gift tax is payable as the donor is not a US taxpayer. Also, the US recipient in this case would be required to file Form 3520. This is an annual return to report transactions with foreign trusts or recipients of certain foreign gifts. And if this form has to be filed only if the gift amount it exceeds US 1 lakh dollars. This reporting ensures that compliance is proper with the US tax laws. If the gift amount is lower or lesser than USD 1 lakh dollars, then no form 3520 has to be filed. Also, another important point to note here is that NRIs can give gifts up to USD $13,000 per recipient in a year without incurring any gift tax in the US. However, the key condition is that no individual recipient can receive more than $13,000 within the same year. So this limit applies on a per person basis. So if an NRI is married, then the couple can collectively gift up to $26,000 to a single recipient. So you can break that gift between the two couples. Okay. For example, now if I have to give you an example, if an NRI gives $13,000 to their mother, then he can gift another $13,000 to their brother in the same year. So there's no gift tax liability on these transactions in the US. So it's very, very
Oh.
crucial. So it's very, very crucial to understand these differences to navigate cross-border gifting effectively. So, or what all we have discussed until now. So this will help kind of assimilate or be more informed about when you're making any gift or you're receiving any gift.
So thank you so much, Mr. Garg. I know we'll continue this series, but for now, I would just like to thank you for coming back on my channel and enlightening us as always. Thank you so much.
Thank you. My pleasure. Thank you so much.
FMR Finance Weekly. Simplify your life with our financial advice.